And I guess what it teaches you is that when in all despair, you just don't lose faith, right?
Right, correct. A lot of prayers
Yes, ma'am.
in the last year. A lot of prayers, sir.
All right. You guys take care. Have a wonderful, wonderful, blessed Thanksgiving.
Thank you.
All right.
We have a lot to be thankful for,
Yes.
don't we?
Oh, bless her.
We're still breathing.
All right.
I'll keep doing that.
Take care.
Thank you.
And
And
young
have a
man,
wonderful
you
Thanksgiving.
take care of yourself. All right. You hear me?
Yes.
Yep.
All right.
Doctor's appointment on Wednesday.
Okay. Doc, okay.
Thank you, Your Honor.
Yes. Let's see. Who do we have here? Northville Crossing versus Tony Rogers. Did you have one? You did have one more, correct?
I don't. Which one do you have?
I have Tony Rogers.
Is it TONYROGERS?
Yes.
Hold on.
TAWNY.
Tawny Rogers.
Tawny. Yes.
I show that this was a dismissal, Your Honor.
Got it. Okay, that's fine. We just, paperwork isn't here, but that's okay. Case is dismissed on plaintiff's motion without prejudice. And then let's make sure we got. Yeah, and Northfield Estates versus Grabowski and Northfield Estates versus Powers. Those matters are dismissed on plaintiff's motion without prejudice. Fantastic. All right. Young lady, you have a great Thanksgiving, huh?
You too.
And this is the first Thanksgiving with the little one, right?
Yeah, Miss Dornbush will be back, I believe, the first week of December. So I was told she's going to be thrown right back into court. We'll see if she'll be here on the 5th or if it'll be me.
Okay. Well, all right. Well, you have a blessed Thanksgiving.
You too, Your Honor. Have a good weekend.
All right. Take care. Court stands in recess. These folks are here for something else. Right. I thought they were done. I'm sorry, man. So the repairs still haven't been done?
Your Honor, I can get in touch with my client and see what's going on with that. Can I, if I give Ms. Jones my email address, I wouldn't mind looking at a list just so that I can have something to go through with my client.
Okay.
Um,
All right. And ma'am, the amount that you were going to pay on the 28th, pay that also in the court escrow.
Okay.
Okay. All right. And then when were you gonna pay then your December rent normally? I mean,
So the December is like what, the first? I was gonna try and pay it with that one, so.
oh, so you're gonna try to pay the balance plus your December rent. Great. If you do that, I want all of it in escrow
Okay,
till they,
okay,
all right. So what I will do with your case then, ma'am, is I'll adjourn it out to December 5th, 2025 at 2 p.m. All right. And I've noted my file that the repairs from your standpoint are still not done. Okay. All right. They'll get a list. Put that in there. You just get to keep coming back and seeing. All right. All right. You have a great Thanksgiving.
Thank you, Your Honor.
Eladot Property Management versus Nicole Freeland. and Aaron Gates. And the one that's running the whole show. So her legs are like this big. And then just like parents do, can you sit here? She was gonna give it her best shot. What are your names?
And Nicole Freeland.
You really should let her go first, but I'm not gonna hold that against you, but maybe I will. All right. And where are we on this?
I have a balance including court costs of $3,394.33. I do note that the ledger reflects that $400 was paid on the 14th. I think that there's gonna be $400 today, but obviously that my ledger wouldn't reflect.
We just paid that before we came, so.
Okay.
You
Yeah.
paid that before you came in?
Yes, yep, and I took a screenshot just in case you guys needed it. so.
All right, that takes them down basically around the $3,000 mark. All right, how are you guys gonna get the rest of this done?
We signed up for the SER. Did the clerk send you down a paper of that?
Yeah, so you did the SER.
We did the
Yes, you want
SER.
to wait to get back with us?
We also tried Hawk, but they haven't gotten back with us, so, yeah.
So Hawk hasn't gotten back with you.
So,
All right, there are how many in your household?
the two of us plus her, so 3. I don't know if you count.
How she said that, the two of us plus her. No, she's in the household and
Yes, so
she's
3.
allowed you two to.
So 3 of us.
Yeah, okay. So that you know, and I don't know if I apprised you this before, even if the SER gives their maximum amount, it's only 620.
Okay.
Okay, so you guys are really kind of depending on Hawk and trying to get yourselves caught up, right?
Yeah.
Okay, how much is their monthly rent?
$1,350.
Okay, so this 400 that you're paying, are you, so that's, what's your plan to keep your rent current?
Keep our rent current, doing the best I can, to make some small jobs, extra money on the side right now. I'm sorry.
And then I have to get like 400 a week my job because they're taking money for her because I can't afford daycare for her. So they've been taking money out of my account or my check. So I'm only down to $400 a week. Yeah.
What do you mean?
So I used to make 600 because I work for a company that's a daycare, but because they want 50% of childcare for her, I'm unable to pay the childcare because he's lost his job and now we're down further in mine because my employer is asking me to pay out of my paycheck for her childcare. So now I'm down to $400 a week. And this is why we kind of got somewhat behind as well. So with him not being employed and trying to get these side jobs with also applying for other. I know.
No, I'm hearing you. I'm still trying to figure out the childcare thing. So she stays at a childcare with your employer.
Yeah, so I work for this employer and she's letting me bring her, but we have to pay $187 a week just for her to come. And now I'm behind with them, so they're like, well, you have to start taking money out of your check to pay for her childcare, and yeah, it's just.
No, I got you. Okay. And you're still trying to find work.
Yes, sir. Just did get a car about 2 weeks ago, so
Pardon?
we just got a car 2 weeks ago, so now I can.
We can farther a little,
Okay.
they're staying in the
Walking
city.
Chelsea.
Yeah.
Problem so here's gonna be part of the issue. You said your rent is
50, isn't
$13.50 a month, so
it? I was gonna say plus the utilities, I think it's almost like 13, almost 14, but yeah, they pay.
okay, so let's just work with the number 14. The problem is if I adjourn this out, 1,400 is gonna kick in. When that 1,400 kicks in, when Hawk calls you back, you have to get that to where you are right now, which based upon if nothing else were to change, that's going to take you get paid every week, right?
Mhm.
So that's going to take you 3 weeks to get back down in that $3,000 range.
Mhm.
Is the landlord amenable to any type of
As far as I know, Your Honor, I don't think that a payment plan is, as far as I know, I can ask about a payment plan, but I don't know that that is something that they would offer. at this time.
I mean, I can't necessarily force them to do that, but I mean, well, they're truly between a rock and a hard place
Right.
because I mean, if she stops working to stay home to care for the child, then that 400 isn't there.
Right,
Mhm.
I assume he's trying to do the best he can to get himself employed. He's like you said, he's getting a car just so he can sort of expand the areas that he can.
Your Honor, I suppose if you adjourn it over point of deduction to the 5th, then will be 2 weeks. I mean, December rent will have kicked in, but that'll have been 2 more weeks to get, about 2/3, a little under 2/3 of that.
Right, okay. We're spending too much time together. You're reading my mind. So folks, let me just ask you this, because I just gotta know. If your check is 400, and I realize he's doing that, how are you?
We're, we're we're rounding. I mean, we're trying other things. We're even thinking of taking everything, even these guys, and putting it in like, just go what is it? Bankrupt? It's just starting fresh and just being like.
Okay,
everybody
no,
pays, you know what mean? Like,
hear, I hear you, but
It's one of,
I'm asking a more basic question. Okay, just this.
know.
If I said, I'll adjourn it out, but you're to pay the 400 a week, how do you guys eat?
I bring in cash on the small time jobs, kind of like doing mason work, brickwork and stone jobs. I like barns and whatnot. I'm doing that to feed us for the most part, put gas in the car, and she's taking care of most of the bills. So. Trying my best. I mean,
And that's what my employee said, why doesn't he just stay home with him? And I'm like, but if he stays home with him, how is he supposed to be able to find a job? Yeah, it's just,
I can't take her on jobs.
yeah, so.
All right, well, I'm looking at her, she looks like a stone mason. That's
Probably give a good effort.
right, she can help out. You just tell her where you need to put that. All right, here's what I'm gonna do. Because and again, over the objection plan, you guys are just trying to figure out how you're gonna do that. You gotta put food into your mouths, you gotta put food in that little baby's mouth and everything. And at some point, try to figure it all out, right? I'm going to adjourn this case over the objection of plaintiff to December 5th, 2025 at 2 p.m. Okay. You paid 400 today. So over the next 2 weeks, I want 350 paid to the landlord. I don't, I'm just thinking about the math and I'm trying, bottom line is, if you guys fall out, you guys don't get this thing paid and that little one needs both of you. All right? Plain and simple. So take that extra $50 and make sure you've got what you need
Okay.
to be able to feed yourselves and your family. Okay?
Okay, thank you.
And then, so pay that $350. She'll talk to the client, try to figure out what to do, and we'll figure out what we're gonna do going forward.
Okay.
Okay, fair enough?
Yes, thank you.
All right. You guys have a blessed Thanksgiving.
You
What's the
too.
little one's name?
Anna.
Anna? Anna, bye,
Say bye.
bye, bye. Did she say bye?
Oh, yeah.
Or she just screamed at me? Bye.
Can you wait? Can you say bye?
Can you wave it? Bye. Oh. Okay. Come on, Daddy. Now my day's made. That's right. And you notice something that Dad did? Dad did not hesitate. The moment she said, "Come on, Dad," he just shot out. That's right.
Higher authority.
The power of a daughter. Cherry Hill Administration versus Dion Ragland.
Jillian Angus for plaintiff.
Yeah, she went out to. I'm gonna pass it real quick because she's talking to them. Okay, I got. No, I got you. Evergreen Apartments versus Thomas Fleming. And at LT Johnson.
She's incapacitated
Okay,
and she has dementia. This is my case manager from
Okay.
CMH.
CMH. Okay, come on now. What's your name?
Thomas Fleming,
And your name, sir?
Scott Moore.
All right, thank you. All right. Where are we on this thing?
Your Honor, since the last hearing, I have a report from my client. So there was an inspection on the 14th to go over what needed to happen before treatment on Monday. And then on that Monday, the 17th, Terminix visited the home. And it sounds like the home's not adequately prepared for effective treatment. So obviously this is a health hazard and safety case. And so there's just the home is attracting pests, and it's it sounds like there have just been some problems getting the house prepared for treatment. And it's affecting other units.
So what happened, sir?
Okay, so they came on the 3rd and they sprayed. And it
Right,
wasn't
and they
complete.
need,
And-
right, they
but-
needed to
but
come
the
back.
problem is that I'm taking care of an 89-year-old and I didn't have any help. We moved into this
Got it.
apartment from my home and there's a lot of stuff in there. And my nephew didn't come and help me until the end of October. It's an ongoing process. I spent a lot of money trying to get the house prepared. I got the clothes up. I bought tubs that cost about $100. I bought paint. I painted the wall because there was fecal matter from bed bugs and eggs. I painted over that. And also, they didn't come on the time that they said they were coming. They said they're coming the 3rd, the 10th, and the 17th.
Right, but when they came back on the 17th, if the unit's not,
They only did one room.
but sir, and that's because they're not going to do the rooms if they're not prepared.
Well, it's kind
Proper.
of hard to move my mom and her hospital.
Sir, I hear you. I'm just trying to figure out somehow or another this impasse that we're at has to,
Well, for
got to
one
get
thing-
past it.
I'm sorry, Your Honor.
Go ahead.
But for one thing, I didn't have the paper that tells me how to prepare the home because someone, an old neighbor of mine, Michael, who has been helping me out. And he took that paper and he was supposed to make a copy. He never gave it back to me. So I didn't know. I was only guessing at how to prepare the home. He never gave it back to me. So I was only guessing what I needed to do. And I've done a lot. Every time they've come, it's been more improved.
All right.
So if I know what, go ahead. So if I know what needs to be done,
Do they have, does that list come from Terminex or does it come from your client about preparation?
I'm guessing it would come from Terminix, but obviously that's a guess. I can.
Right.
answer from my client.
All right. So
it didn't come on the 10th at all.
okay. But understand the part of the reason they're not showing up is because the unit's not prepared. And then when they do show up, they can't spray because it's not prepared. I understand and I hear all your difficulties, but it can't.
Well,
It can't keep going.
he sprayed on the 17th. And I couldn't get into my room for three hours and I had to sleep on the floor.
Right. I get that. But here's, and I'm just gonna give you the bottom line to it. If we don't get that unit sprayed and properly treated, then I'm gonna have to issue a judgment and have you evicted.
Oh,
That's the bottom line. And I don't necessarily want to do that.
yeah.
Yes, sir.
I just found out kind of about what's going on. I will happily assist Kevin and try to get his to come.
Got it. Okay. So it's pretty much on a 2-week kind of cycle kind of thing. So
Oh, sorry.
here's what I'm going to now. I have the 12. What I want to have happen is I want the landlord to send out the list of how that unit needs to be prepared. If to the defendant as well as if the CMH worker can give a email address so that it also goes to you. Okay. Send that out, have them set another appointment for the spraying and treatment of the unit. And let's see if we can get this done.
Brenner, would you give a deadline for the appointment so that we all know kind of when it has to be prepared?
For the appointment, well, I was thinking of adjourning it out to the 12th, but with the holidays, I don't know if that's going to be enough time. Can they get Terminex out in a week?
Yeah, oh yeah,
Okay,
that's not a problem.
so I'll adjourn this out December 12th, 2025 at
Yeah.
2 p.m. All right. And I'm going to indicate your unit needs to be fully prepared for treatment.
Okay.
That was going to happen. You're going to have your unit fully prepared for treatment by the 10th.
10.
Yes, and that way they can set the appointment. Hopefully they can get them out there within that
Between the 10th and the 12th.
part between the 10th and the 12th. They can get them out there. I may be ambitious, but I'm also trying to give time because I know you're going to be. All right. Okay, so 2 o'clock on the 12th, and hopefully we can have a good report.
All right.
Thank you. Court does call the case of Cherry Hill Administration versus Dion Ragland. Council of Records number and can get that to them. I think there may be an email address. You
I've
need
asked-
to send, pardon?
I've got a cell phone number.
Okay. You need to send a copy of your answer to the plaintiff's attorney. You understand that?
Yep.
And you need to file an answer with the court.
So it's both.
Yes, both. You need
Sorry.
to file and send them a copy so they know what you've given to the court. But I'm gonna put you, since you said you already started it, I don't think we need a lot of time. So you need to do that by this upcoming Wednesday, the 26th.
Okay. Thank you.
And then I'm going to get back to the final settlement conference portion of it, council. So from a client's perspective, I'm going to set this for final settlement conference hearing December 2. December 2nd, 2025. That's at 9 a.m. That's an in-person proceeding. So you need to be here at the court. They need to be here at the court. And we'll see if we can resolve this thing short of trial. If not, so that you understand, I'm going to be setting the matter for trial rather quickly.
Okay.
Understood?
Thank you.
Whether you have Mr. Henry's advice or not.
I understand.
That's the way I'm going.
I just thought I was doing the right thing. I didn't know, so.
All right. Thank you, counsel.
All right.
Thank you. Have a good holiday. Court calls the case of Pleasant Lake Park versus Christopher Janoway.
Happy to see you, Judge. Happy to see you, Mr. Allen. I have documents to submit.
What? Oh, just,
David Morris on behalf of Plaintiff Pleasant Lake Park LLC.
thank you.
Thank you.
Your name, sir?
Christopher Genoviak.
Okay. And what documents are you trying to submit to the court?
A counterclaim.
Have you,
Judge.
So this is our fourth hearing. Last hearing, plaintiff presented an inspection, an unsworn statement by an inspector. And Mr. Janowiak asked for 1 week to get his own inspection done. I understand that he has done that. He provided me a copy of an inspection report today, just before the hearing. And I understand from the Register of Actions that he filed a motion to set aside default, which maybe is the counterclaim. I'm not sure.
I don't understand how I submitted the money. I don't know if I did that. I don't understand how I submitted money. I don't think I did that correctly.
how you what?
The money that you ordered to put in escrow, like,
Yes.
it's like a holding, like, you know, you may give me all the money back hypothetically. I don't think I submitted the money correctly. Because I don't want to like, I put $12.30 in escrow because there's a $20.
You did.
Why are they putting this over here?
We also made him fill out this form. That's why.
Oh, I see.
I told you about
Yes,
that.
you did.
Yeah, I think I did that.
No, the money, the escrow's there. We had a clerk that, I don't know why they did this. What they did, counsel, is apparently the only way that they ever saw escrow come in without an understanding that I ordered escrow was on a motion to set aside.
I see.
And so they had to fill out that form, which really means nothing because there is no judgment had they looked.
Yeah, I'm ignorant of my actions. I don't know.
No, it truly, sir, there may be other things that are your fault. This one's not. So, well, okay. You
The proof,
can hand it to me when I want you to hand it to me. You really do not have to bow. Okay? Have you seen the counter complaint?
No, I'm not aware of a filed counter complaint. And for the record, I haven't seen a copy of an answer, haven't seen any writings by the defendant.
Okay, so let me just back up a second. What did your report reveal?
It revealed, conspiracy and perjury by the landlord, Mr. Weasel. And
Oh my
his
gosh.
Investigators.
No, 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 no.
Oh.
You had an inspection.
Yes.
Or,
Oh, the inspection determined that there is a complete infestation,
of what?
of rats. A complete infestation. There's rodents everywhere. Throughout the home in areas like the rotary room and wide open, and you shouldn't see, it's usually a sign of an infestation. The loose material underneath the dresser and behind the stove is from the rats trying to create a nest. The loose material behind the stove is from the stove's insulation. It'd be very.
Who's this from?
It could be a fire hazard. This is from a company called Proof that has over 100 years.
It's
And-
from-
I have colored photos and I have the
You had-
licensed and insured.
Okay, just let me,
Would you like a copy?
thank you.
I gave the kind lawyer a copy of this. Sorry. I don't know if that's, did you give him what I gave you?
Yes.
Okay, so we have. Right, that is what I have. So the technician comments are, there are more pictures I did not.
Okay, were
complete-
these pictures a part of his report?
Yes, sir. Yes, Judge. This is,
Okay,
I haven't slept a single night since August. I called the police twice because I thought there was people outside my house, but it's really just a rat infestation. I've tried to get resolved and they wouldn't do walkarounds. So since August, I
you
haven't.
called
had
the
one
police
night-
on the rats?
This is the rats, yes. There was more creatures. The whole house was just, there was holes in the skirting and there's proof. There's holes in it underneath the cabinets that are connected to the wall. It's a complete rat hotel. I hear them every night, they chew my property. This is complete opposite of what this client said. His inspector is my next door neighbor. There's a conflict of interest in here. There's conspiracy, there's
Okay.
perjury. I might take this to trial to get them on record, so I can later sue them. I
Okay,
might take this
all
to trial to
right,
get them on record.
okay, all right.
I might. You're judge.
Well, we welcome any trial if you would
I'm-
like to file an answer and a counter complaint. Your Honor, frankly, this is the first that plaintiff is hearing of rats. And this whole case it's on non-payment. For weeks or maybe months, the defendant has been complaining of a beaver or a badger under his premises. My client has been taking steps like trapping, poison, inspection under the premises, outside of the premises. We file a non-payment complaint and the defendant still did not raise this issue. First hearing, second hearing.
Trust me, counsel, I remember everything
Thank you, Judge.
on this, and I just. What's in your counterclaim?
My counterclaim, Judge, has a photo evidence of a complete rat infestation, the complete opposite of what.
Okay, but is that the counter complaint?
I mean, this is enough for his client to be convicted of perjury and conspiracy.
I don't know what that means. I'm just asking, is that your counter complaint?
Yes, Judge.
Can I see that? And counsel, I'll let you take a look. I just am trying to. Oh. Lord, yeah, we'll see. Here. It's the report.
Yeah, that's mine. Yeah, this just proves everything that he's been saying the whole time. Because this is a licensed and insured rodent pest control with over 100 years of experience. And his rodent and pest control man lives on the same property that Mr. Weasel owns, which is a conflict of interest. and he's not licensed or insured. The inspector doesn't even own his own vehicle. He lives with his kind elderly father. And he used this.
Sir, do you understand that that
I don't understand.
is not, it's clear that that is not a counter complaint.
Should I put it in writing?
Well, that's usually where it starts.
Okay, I
Yeah.
know there's an order of operations and proper, you know, ways of operating here. I thought this was sufficient for the court, that this is a professional who's licensed and insured with multiple lines contradicting the plaintiff's claims. And I want to make a deal. I want to leave. I feel like I'm being attacked.
You want to go?
My deal is, my proposed deal, is not a serious one. I do want to go, but.
I don't know what that means.
Yeah,
What do you mean?
I would like to hear a deal. I could propose a deal, but I mean, I really want to stay here and get this rats out of my bedroom. It's literally in my bedroom. It's literally I have a stick just to poke the rats underneath the dresser. I literally have a rat stick next to my bed. For the record, I literally have a rat stick next to my bed for 5 months. So I could put this in writing. And I'm sorry to waste court time. I've been trying to make a deal, but I tried to do a walk around and I tried to do a proper investigation months ago, but,
Okay, sir,
yes,
there are certain ways that you would have to do an answer and a counter complaint. Okay? And you need paragraph by paragraph laying out your allegations as against the plaintiff, as well as answering the plaintiff's claims in this case. You follow me?
no, I don't understand. I thought I did that when I first did the paperwork for the contract, like, it says like, how do you respond to the claims? And I was just like, yeah, I disagree with everything but like the money portion. So, you know, I just thought this was like pretty cut and simple, like, you know, if there's a fly in your steak, you know, you're not gonna charge it for potatoes.
But sir, you started out with like a beaver or some large like badger type animal under there. Then when you came back the last time, we weren't talking rats, you were talking about mice and the baseboards being ground zero and all of that stuff.
Yeah.
Now I get here today and now these mice have grown and now they're rats.
Oh, yeah, the problem's gotten way worse. I agree with you, Judge. Problem's way worse now.
You're not really saying the mice grew into rats.
I'm saying that the rats have been there the whole time and that we haven't done a proper inspection. Yep, proper since the beginning.
All right.
Sir, Judge.
Sir, go ahead.
It's plaintiff's position that to the extent this is a defense about habitability, that this is the tenant's willful and that the tenant has caused these through irresponsible conduct or lack of conduct. To the extent he has a rat stick or anything else, this is the first plaintiff is hearing of it. This should have been.
Heard a rat stick.
This is to the extent the landlord should have trapped, should have baited, should have taken any steps, we needed to have been made aware. We were not made aware. It's clear to me that defendant has taken no meaningful steps to resolve the issue. His living conditions invite the issue, and that we can't be in a position, the landlord cannot be in a position to check in on the defendant to ensure that his quality of life is where maybe it should be. I submit to the court that there is no tribal issue here. To the extent the court disagrees or believes that there should be another chance to file something in writing, I think this needs to go to a trial, a short trial.
I want a bench judgment.
I'm sorry?
I want a bench trial. Judge.
Well, that's all you're entitled to at this point because I don't have a jury fee. So
Correct.
So
one other point for the record, Your Honor, is that management understands that. So there have been attempts to go out for the beaver or badger, and there have been attempts to assist with skirting and other various issues raised over the months. Management has been responsive, but understands that there was at some point, defendant in the last month or so made a comment to a neighbor saying that he would shoot management if they came and knocked on his door. He also claims that management has stolen hamburger off of his counter. So we're not sure if these allegations or threats are real, and we have to assume that they are. And this is part of management's concern, is that frankly, the situation has broken down. And I think a trial would show that there were no attempts to bring management in on the rat, the mouse, or other issues other than the badger or beaver. And those have been proven or shown through the unsworn statement to be flatly false. Mr. Janowiak's inspector clearly did not see any signs of a badger or beaver either.
Hey, so how long is it gonna take for you to put your complaints in writing to the court?
I don't understand what I should put,
Well, you're gonna need to understand.
because I thought this was, so I'll put, so I know I'm not asking you for legal advice,
Good,
But I
I
need to
won't
just-
give it to you.
right? So, and this is quite the maze. And that's my ignorance. So I can put something in writing within 7 days, once I understand what to put, that's gonna be acceptable to the
All
court.
right, you're gonna need to get to figure it out in the next 2 days. The defendant to file a written answer.
A written answer to what? A written answer
To the complaint.
to the complaint, and the complaint is what, Judge? I don't know, I don't understand what the complaint is.
All right, you got served with a complaint. That's what brought you here. You need to file an answer to that complaint. And if you got a complaint against the landlord, you need to file what's called a counter complaint, or your complaint against him. That, you keep trying to hand me, is not a complaint. It is not a counter complaint. It is nothing for the court at this point.
I don't understand. So I will submit what so
You're to file a written answer and or counter complaint.
to the court.
You're to do that by December 3rd.
Yes, Judge.
Filing of that will only be complete once you file it with the court and you serve counsel with a copy,
I don't understand how to serve counsel.
usually by email.
I don't have proper access to email all the time. That's why there's like lack.
Okay, get a stamp, put it in an envelope and send it to him.
Gotta get it twice a year, basically. Judge.
No, you gotta, when you file it with the court, you have to serve them a copy, because you have to acknowledge that you've given them a copy of what you're filing with the court. Then, so you're to do that by December 3rd. I will give you time to look at that. I'm gonna go right to final settlement conference on it. And so I'm gonna set a final settlement conference on this case, which is the step before we go to trial. Set that for December 9th, 2025 at 9 a.m. That is in person, and all parties must be present. Now, I'm going to let you know, I want you to understand this, sir. I have a lot of latitude if you don't follow the court's directions. So if you don't file an answer or a counter complaint, but if you don't submit something in writing in its proper form, I'm going to grant them possession. I'm going to grant them a judgment. I'm just going to let you know that.
I will submit a written response. So,
Is there anything else?
no, Judge.
I have great trepidation to ask.
What trepidation?
Never mind.
Could you define that?
Never mind. No,
I don't understand what.
I'm saying I didn't really want to ask you if there's anything else because I didn't want to hear anything else. All right, just to be blunt about that. But as a matter of courtesy, I have to make sure that everybody's been heard.
Yes, Judge.
Is there anything else?
No, Judge.
Sweet. Thank you. Everybody have a good holiday. Is this your only copy, Council?
Yes, it is.
All right, so
I'm moving.
I'll. Court's gonna stand in recess. I'll be right back, I swear.
All right.
Bye.
You may be seated.
The lease is not a,
Fixing housing, 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing, 401k plan.
good afternoon, Donna Tope, on behalf of Erica and Aaron Ward. They are the tenants in this lease.
All right. Where are we now, folks?
So my understanding is after the long conversation that we had last Monday, that this hearing was held in anticipation of my action or interaction. And I would, if I filed a withdrawal, then the hearing wouldn't be held. And
If you filed it with, I don't think I said that.
well, you didn't say it, no. But you said that if circumstances worked out the way you were suggesting, there were two choices, and that's why this hearing was being held. Do I not have it correct?
I don't know what you have. Keep going.
Okay. So I'm here because I would like to make this statement to the court on the record. This case is a landlord-tenant case. I repeated that in our answer that was filed with this court. The lease is not a commercial lease, as plaintiffs and this mentioned several times. The lease is between an LLC landlord and a married couple, Erica and Aaron Ward. The lease specifically states the lease is for their use as an animal farm. The property is zoned agricultural and has been used lawfully for over 25 years as an equestrian center with several major outbuildings and one residential unit. This lease began in 2021, just 3.5 years ago. The lease terminates in 3.5 years from now. None of the land is zoned commercial. None of the property is used commercially.
Why are you telling me this now?
And the lease is not a commercial lease because several times plaintiff has referred to this as a commercial lease. And I heard this court repeat that this is a commercial lease. There are different standards applied to commercial property and commercial property that is leased.
All right, then all you have to do is say, without this long rendition, that you don't believe it to be a commercial lease.
Okay. Well, I felt I need to just restate what I had said in my answer. It didn't seem to have been heard. I have been associated with Erica Ward.
I hear everything. Now, whether I react to it becomes a whole different thing, but I hear everything. Go ahead.
Well, I have been associated with Erica Ward for over 3 years in consultation with me as a property manager through my solo-owned property management company. She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent and pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer filed with this court had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023, which is his duty under the terms of this lease for agriculturally zoned property.
You
Erica
can't
Ward.
have it both ways.
Hmm?
You can't have it both ways. If you're going to claim, so, and counsel, before you go on, I think you need to do your legal research. If you're going to claim that this is not a commercial lease,
Yes,
and it's a 7-year lease,
yes.
then the obligations regarding repair change.
That I think that would be something to bring up by the plaintiffs to rebut what I'm
No.
saying.
Go ahead.
Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste and interference with her use of the property, which had caused her damages. This complaint was
Counsel,
filed
I don't know why I need to know all of this.
because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem, counsel. That is what I indicated. If you don't see it as a problem, then so be it. But I think on its face, it's a problem. Any question regarding your ethics is your own. Because I'm going to tell you I'll tell you right now, if an attorney comes before me and I think that they have done that, something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that.
No,
So don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're going to be found in contempt. I'm done, Ms. Tope.
Yes. Yes.
What I said to you and what I was indicating is that you took, as you stand before me, the wards are your clients. What I am then told is that you took funds that would have been client funds and somehow took them into your possession to redistribute. Your argument may be that you did it for other reasons.
I would like to state the facts behind the assumptions that I took client funds. I did not. Erica told me that she wanted, I was consulting with her as a property manager. I was not her attorney.
Then if that's your position, that's your position. From the court's perspective, it looks different, which is what I was pointing out.
Yes, and you clear, and I'm
And if
trying,
I want to make an accusation, Ms. Tope, I am not shy. I will clearly make that accusation, and I have not.
you were very clear that that was not an order, it wasn't an opinion, it was words. But I tell you that words have consequences because we are on YouTube.
So does one's actions, Ms.
Yes,
Tope.
yes,
Whether YouTube or not, it doesn't matter. This is a public record.
yes.
And all I am telling you is that the court saw concern.
Yes, and I am here to address the concern so that it's on the record as well, so that,
Ms. Tope, no. I have given my admonition at the last hearing. The wards may proceed in whatever fashion they wish. You may proceed in whatever fashion you wish. If I thought you were doing something unethical, I would myself remove you from the case. I have not done that.
No.
So I am done with this issue.
today. You are done with me today, or?
I am done with that issue.
Okay. Thank you.
Your Honor, this is the first I'm hearing about a property management company that's holding rent payments. I don't know who the property management company is. I don't know what the bank account is. You ordered tenants to produce an accounting. They did that. It's a mess. And my client is the one who's being prejudiced by that. Actions do have consequences. And the consequences of their agent or the actions by tenant's agent have consequences. And they didn't have the right to withhold rent payments. That's what they did. These are grounds for default under the lease. The lease should be terminated and they have to deal with the consequences. Now, if tenants, they may have their own recourse separate from this action, that's their decision. That should not be with my client, and my client shouldn't have to keep fighting over alleged ethical violations.
They did not have a management agent. She consulted with me about my opinion for over 3 years. I had no jurisdiction over the property. It was completely Erica and Aaron's tenancy, and I was not their attorney.
So,
Was I their property manager?
Ms. Tope,
Yes.
it's those statements which give the court pause. When you're saying that they consulted with you regarding the property, and
Not in my capacity. I was taking riding lessons and she was telling me what was going on, and I gave her some of my advice, but not in a professional or proprietary or
do
contractual
it that way. Okay. All right.
No, as a friend.
Okay.
I think Ms. Hope's property management company should be a party. She has inserted herself into this litigation. And this went from a simple non-payment of rent and has ballooned because of tenants through their counsel's actions. And it has become a mess.
We filed a circuit court case was filed July 9th, long before this court had jurisdiction. In my first response as their attorney for this court, I asked for an escrow fund to be set up, a trust fund to be set up by the court. And you did that. Anything done before that was not in, there was no money put in any trust
Can
fund.
I just say, so this, let me just ask this. Council, are you
I need to step closer to here. I'm
Are you going, we can get the equipment for.
Very good.
Council, are you going to file a motion to add Ms. Tope and this as a party to this action? I realize I'm asking you on the spot because you're first hearing about it. And I know there would be things to be taken into consideration in doing that.
Obviously, I'd have to discuss with my client. It's something that I would like to avoid. I think the language of the contract is clear that they didn't have the right to withhold payments and that these are grounds for defaults and that the lease should be terminated and there should be an eviction order. But if we have to keep going this back and forth way, we may have to. Especially if it's a third party that's handling funds, handling the rent funds, then we would have to.
No.
So
Yes,
were you the property manager for them?
no,
Were you involved in the payment of funds to contractors?
only in the account that Erica used to withhold her funds and
What do you mean by that? Who were signatories to that account?
Erica approved all of,
Who were signatories to that account?
I was,
There's our problem.
but not my
Okay,
attorney.
so no. That's our problem. So who else was a signatory to that account?
No one else. Me and me alone. And
Okay, Miss,
the money was filed after we filed the circuit court case.
no, doesn't matter.
And this court.
Doesn't matter. Doesn't matter. It doesn't matter. Do you not see a potential problem with that, Ms. Tope? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it. But I don't see a legal problem. So when you say a problem,
Let me ask this,
yes,
since you're given that information. And just think about this for a moment.
okay,
Whether you believe it to be true or not.
okay,
Plaintiff claims that the tenants cannot withhold rent in this fashion or make repairs and take that off of the rent. Okay? Tenants do that.
Tenants had done that before they
Whoa,
claimed that.
whoa, 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 whoa. Tenants do that. Tenants acknowledge they've done that. And that you are the one that did that on their behalf. Why? What happens given that factual scenario, which I don't think is far from the truth based on what I know, if they file a claim not only against the wards, but also as to you?
I'd have to show why it's not appropriate. Mostly because they were notified that rent would be withheld before it was withheld, and they were notified the bank account that,
So if
Yeah.
their claim is you can't do it,
well, I
if
guess,
their claim is you can't do it,
yes,
and that the wards could not do it, but then you were the one that did it on their behalf, good, bad, or indifferent, you're the one that did it. Don't you really yourself become a necessary party to this action? And that's what I'm saying. If you're a necessary party, Ms. Tope, you can't be the attorney.
okay. Okay. I hear what you're saying.
Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, it's not my issue. You understand what I'm getting at.
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing was I did not want a circumstance where Ms. Tope, you're brought in as a party and then your clients are left without representation. It's just an issue of the fairness of all proceedings. It doesn't have to do with whether I like somebody or not, or what position I'm taking. So, Ms. Tope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track for sure.
That what?
We are on this case. We are off track. Get it back centered. I would do whatever's required to be able to deal with the issues at hand and not clog up these proceedings any further.
I don't know what that means.
Well, I'm sorry, that's the only way I can say it.
Your Honor, we're off track due to tenants' agents' conduct by taking actions that were not allowed under the lease in the first place. And this is our third hearing in 3 weeks, and my client is going without any rent payments. He got a partial payment, but he is the one who's being prejudiced by us having to keep coming to court when tenants didn't have a right to do this in the first place. And they have to accept the consequences for their agent's actions.
I was not their agent.
Okay. Then what were you?
I was their friend, and beginning July 9th, I was their attorney in a circuit court case. And they did it
I
by,
know what, I know what, I'm not gonna go through what you want, what name you want to place on it. Counsel, you know how the terms agent are defined under Michigan law. So the fact that you are somebody's friend
Mhm.
does not mean, for the purposes of agency law, that you may not be acting as their agent.
well, that one would have to prove I was acting as an agent rather than a friend in order to put the official together as an agent.
Ms. Tope, I don't even know how that comes out of your mouth. If you're saying that they had money in repairs that needed to be done on property that they lease, they own the property that they're leasing, and that you, whatever name you want to place on it, take funds as the only signatory to an account of theirs and do things with it, reference the property, pretty much acting as their agent.
I will prepare withdrawal papers and have them sign it. We've talked about this. They're in agreement after this.
Then why don't we start there? Nothing. All right, so you're gonna withdraw as counsel?
Yes,
All right. And then, folks, are you in the position right now that you have counsel, or how? No. How much time would it take you folks to get an attorney? What do you think?
Wouldn't know where to start, so I have to look into that.
We typically offer.
Pardon?
You typically suggest.
Well, I don't know. I don't want to bring you back for a hearing and you don't have someone to represent you, but I about to go into December. December, the escrow is going to have to be paid. So while plaintiff's not getting it, it's going to have to be paid to the court. And escrow was deposited with the court. If you don't know that, it did get deposited.
Your Honor, I received a handwritten note. I couldn't read it, but that's good to hear that they did follow.
The handwritten.
I received a handwritten note that I don't know what.
oh, that was my written request because the court was not available Friday after our hearing. That we went to the clerk to pay the escrow, and we were told that we had to get permission from the court.
To pay it in certified funds as opposed to cash. Yes.
They paid it, okay.
And I filed that with the court, and I gave you a copy so that you knew what I had done in order to try to get the amount paid. And they also advised me that since this case is really in 14A4, but they can't take funds here at 14A1.
Yes, they can.
Well, they say that it's put into a bond and it's very complicated and,
I don't care how complicated it is. They can take the money.
well, okay,
They don't have to drive up.
I deposited it.
It doesn't matter.
I like
Whatever.
the drive. It was a nice drive.
Okay. So the 4125 is, my point is that that is in escrow.
It has been paid.
And that I have the expectation that the 5,500 will be paid within days of December 1st. All right. So I'm going to give the wards time to find counsel. So I'm going to adjourn this to December 19th. Allow them to get counsel and allow counsel to, once obtained, to get up to speed on everything that has transpired.